Hello friends, in the series on the income tax cases, today we will discuss the case of Pradeep Alexander. Second party was Academic Charitable Environment and Research Foundation versus Tax Recovery and others. This case has been reported in 448 ITR at page number 720. The matter has been decided by Madras High Court. In this case, the assessee was before the Madras High Court against the order of the attachment under section 281. Section 281 is not very common section, but it is very dangerous section and the provisions are very harsh. The provisions of section 281 are a little bit impractical also. The similar provisions are there in the GST Act also. Section 281 of the Income Tax Act broadly says that certain transfers are void, meaning thereby that if any person purchases any property from an assessee who has outstanding demand on the date of the purchase or outstanding proceedings which ultimate culminate into the income tax demand, then the department can declare that purchase of the property as void. The conditions are that if the assessee has purchased that property for adequate consideration and if the assessee does not have the knowledge of the outstanding demand or proceedings against the assessee, then in that case the property will not be void. But my point is that how the assessee will come to know that the person from whom he is purchasing the property does not have any outstanding proceedings or outstanding demand, because we have seen that in the normal course of life, no one is going to verify from the seller that he has outstanding demand or he has outstanding income tax proceedings. Although there is a procedure in the section 281 itself that the assessee can apply or the seller can apply to the department and get the no due certificate from the department. But if the assessee will go for this certificate, then it takes a lot of time and the property transactions do not have so much of the time to wait, because these transactions are very sensitive. In this particular case, the petitioner purchased the property 25 years back from a person who was having outstanding demand. When this property was purchased, after that property was attached by the income tax department. So the assessee was not having the knowledge of this attachment at that time. But the income tax department again initiated the proceedings under section 281. The notice was issued to the petitioner and the petitioner went to the Madras High Court saying that the department cannot take my property after 25 years. And this was logical also, because there is rule in Income Tax Rule 68B which says that if any property has been attached by the Income Tax Department, that property cannot be sold by the Income Tax Department after 7 years. Meaning thereby that if you are attaching any property, then you have a time limit under which you can sell that property. So even if the department is going to reinitiate the proceedings or to restart the proceedings on the same property after 25 years, that will not be fruitful for the department, because Rule 68B prohibits that. Friends, although in this case the assessee got the relief, but when I read this decision, then this is a very dangerous situation for any person who has purchased any property, because it can happen to any assessee. Because we in our normal life, even the professionals and the various persons purchases the property, but I have never seen that the people are taking so much of the care that from the person to whom from whom he is purchasing the property, he is going to verify that whether your demand is outstanding or not, whether any proceedings are going or not, because these type of things will never be communicated by the seller to the purchaser. So this case gives a clear message that we should be very conscious, we should be very cautious when we are purchasing or we are dealing any property. And more interestingly, section 281 is not only includes the immovable properties, it includes all the properties. Friends, at the end of this video, once again, I am repeating the name of the case. The name of the case is Pradeep Alexander, Second Party Academic Charitable Environment and Research Foundation, and the matter has been reported in 448 ITR at page number 720. The matter has been decided by Madras High Court. Thank you, friends.